Hi guys, today we're going to talk about the Constitution. Now, how did the Constitution come about? Well, in May 25th, 1787, the delegates met in Pennsylvania to revise the Articles of Confederation. Some people just thought they needed a little bit of change. Remember, they wanted a stronger national government. And lots of them came with that goal in mind, to get a stronger national government, to solve the problems they had with money, to solve the problems they had with collecting taxes, to have a national army, those types of things. So they wanted a stronger government. Some delegates wanted a completely new and revised plan. And that's kind of how the Constitution came about. The Articles of Confederation just weren't strong enough, so they were looking for something a little bit stronger that would unify the country a little bit more. Now, who was involved in making this? It was a big deal for our country. It was a very important thing. So they picked some very important people, some people we've already heard about. Ben Franklin was the oldest delegate. He was 81 at the time. James Madison took lots of detailed notes. And his notes are one of the sources that we have of what happened and what they talked about and what was important that happened in the proceedings. Patrick Henry did not come. He argued strongly for independent states. He thought the states should have the power, and he kind of thought that one central government body would A, become a lot like the king that they just got away from, or it wouldn't be able to make laws that every state would agree with. Then we have George Washington. He attended and he was elected president of the convention. So he helped the convention run and keep order, those kinds of things. Then we have Alexander Hamilton. Hamilton agreed that the government under the Articles of Confederation was too weak. They needed a more unified front so they could be taken seriously in the world and to help the citizens. One of the biggest debates was over state size and who would have the most say. Bigger states with more people, and then the smaller states wouldn't get the same say. Or could they have the same say, but then there'd be more people and they'd have less representatives? And that was a big debate. Edmund Randolph brought the Virginia Plan. This called for an executive branch and a judicial branch. So that would be adding the president and courts to what they've already started with having a Congress. He thought that the larger states should have more representatives in Congress. He was from Virginia. Virginia was one of the bigger colonies, one of the bigger first states. So he thought states like his should have more of a say in the Congress. The small states didn't like this because they thought that no one would care what they thought. They were a small state, they had less representatives. It wouldn't be fair, their people's voices wouldn't be heard. So then we had William Patterson. He brought forth the New Jersey Plan. He was from New Jersey. It was a smaller state, had less people. It was very similar to the Virginia Plan. He wanted a president and courts the same way that the Virginia Plan did. However, he thought all states should have the same number of representatives. He thought that would be a more equal power source. However, the big states didn't like this because they had more people. They thought, well, if we get the same votes and we have like 500 people and we get one vote and we have 50 people and they get one vote, well, their vote counts more than ours does. And neither side could agree. They couldn't come to a compromise. They both wanted their states to feel like they had equal power. Then finally, we had the Great Compromise. Roger Sherman from Connecticut said, you know what? We all agree. We should have a president. We should have courts. So we'll have the Congress, the legislative branch, we'll have the executive branch, and the judicial branch. But let's go ahead and talk about this legislative branch. Instead of saying, we all want it this way, we all want it that way, let's split it up and compromise. So he said split Congress into two houses. The Senate, where all states would have the same number of representatives, and the House of Representatives. These would be based on the number of people in the state. So if you were a large state, you got the same number of people to the Senate, just like everyone else, but then you got a few more people in the House of Representatives. If you were a small state, you got your voice heard, you had the same amount of people in the Senate as every other state, but then you had a few less delegates in the House of Representatives. And everyone agreed on that compromise, and they came to that compromise and went on with it, and moved on with the Constitution. Another fiercely debated argument was, should slaves be counted as part of the population for the counts for the House of Representatives. States that didn't have slaves thought, no way! You don't treat them as citizens, you don't give them rights, you're not going to let them vote, why should they be counted? But at the same time, the states that did have slavery thought, but the owners are responsible for helping the slaves and maintaining their economy and keeping all those things important, so they should have a say because they're looking out for more people. And regardless of which side was right or wrong, they came to a compromise. They came to the 3/5 compromise. States could count the enslaved people for taxes and representatives in the House of Representatives, but only 3 of every 5 slaves would count. That's why it's called the 3/5 compromise. We had started with the Articles of Confederation. This group was meeting to revise them. But now they came up with a new plan that would be called our Constitution. The preamble stated the main goals of the Constitution. The Constitution set up our government in 3 branches. It talked about a separation of powers. They didn't want one central governing body to be strong, just like the king had been in England. They split the power up into 3 different branches so that one wouldn't get too strong and overtake the whole country with what they wanted. And they agreed with the majority rules. So when it comes to voting and other things, 50% or more, you have to have the majority of the unit vote with you. When it talked about separation of powers and the 3 branches of government, they set up checks and balances for each part of the government. Each branch could limit the others, so no one branch could have too much power. So let's go ahead and look at the judicial branch. The judicial branch set up courts at the national and federal level. They decided what laws mean, and they decide if laws follow the Constitution. That was their main job. The legislature made the laws. They had the Senate and the House of Representatives. They made all the laws. They could make taxes, and they could collect taxes now. And finally, we have the executive branch, the branch of the presidency. He enforces the laws, and he commands the national armed forces. That had been a problem before for the colonists, that they didn't have a national army, so he's in charge of the armed forces for the nation. But with one branch writing all the laws, and one branch judging and running the courts, and one branch running the country, they were afraid that one branch would get stronger than the other, and the others wouldn't be able to do anything about it. So they put these checks and balances in place. The judges can overturn a law if they think it's unconstitutional. So that's a check and balance to the legislature. The legislature has to think, well, is this law constitutional? Are the judges going to let this law pass? They had to think about that. And the judges could go, hey, did you see this law they made? I really don't think this is constitutional. I don't think this is fair to the citizens. Let's go ahead and talk about that. The legislature, in turn, approved the judges that went on the judicial branch. So they had a say in who became a judge, and they made sure that their qualifications were in order and they were able to do the job. The legislature would pass the laws. The president, though, the executive branch, has the power to veto or refuse to sign the laws into law. So if he thinks a law is not okay, he can refuse to sign it. However, if 2/3 of Congress agrees, they can reject that veto. So the president can say, hey guys, I think this law is silly, I don't think we need this. And if 2/3 of Congress agree, then they can say, you know what, we're going to put it into action anyway. We can ignore your veto. The president also chooses the Supreme Court judges. So the president's choosing, the legislature's approving. So both of these branches are working within the judicial branch. They're checking it. They're keeping it in balance. However, the judicial branch can overturn a president's actions if it finds them against the Constitution. So there's lots of interaction there between the different branches, but what's important to know is that there are 3 branches of our government that help separate the power in the country. And that's all we have about the Constitution today. Next time we'll hear about the Bill of Rights.